Hi, I'm an estate planning attorney, Ellen Cookman, and in this video, I'll be interviewing Rose Pondel about surrogacy law, egg donors, and assisted reproductive technology. So it's a really interesting interview, and I hope you enjoy it. I want to introduce you to Rose Pondel. Rose is an amazing attorney who does a very specialized area of the law. And Rose, can you introduce yourself and let us know what exactly do you do and who do you help?
Sure. So my name is Rose. My law practice is headquartered in Southern California, but I work with clients all over the world who come to California for fertility treatment. So whether it's IVF or they're using a surrogate or an egg or sperm donor, or maybe you're an embryo donor, clients all over the world sometimes come to California because our assisted reproductive technology is quite advanced compared to many parts of the world. I've been doing this for about 15 years and I've worked on thousands of cases. So I feel really lucky to be doing this.
That's awesome. So before we go forward, assistive reproductive technology, can you define what that is?
Sure, it's any kind of reproduction that requires a third party intervention. So, whether or not it's a sperm donation that happens either whether it's at home or in a medical office environment, egg donation, embryo donation, traditional IVF with a couple who perhaps are having some fertility struggles, a surrogacy. So that was a very clear third party where a surrogate's carrying a baby for somebody else. So it's anyone who requires some sort of technological medical for their reproduction.
Okay, great. Well, so now I also practice in California. And can you tell us, under California law, who, in that whole scope of things, who would be considered to be a child if you were, I guess, created in in one of those ways?
So it depends a little bit on your contract, quite honestly. So if you are, let's say you are a single intended mother by choice, and you're working with a sperm donor, you would want a contract between you and the donor, and that contract should really clearly lay out who has the parental rights, who does not have parental rights. The contract should be very clear as to the intended mother, and we call them intended parents because that's the intention of the contract. We want to make sure it's really clear that she'll have all parental rights, that the donor does not have any parental rights, so she can't sue him for like child support, for example, in the future. He can't sue her for any kind of custody or visitation. From that contract, whatever child is conceived under the terms of that agreement is a child of the intended mother. So that child should have inheritance rights, just like any other child from that intended mother, should not have inheritance rights, for example, from the sperm donor. And with like a surrogacy contract, same thing, where we have maybe one or two intended parents who are working with a surrogate. The contract is very clear that the surrogate does not have any parental rights or responsibilities to the child, that the parents have full parental rights and responsibilities. And that would include things like inheritance as well.
Now, so does that, I'm thinking about a few movies where, there's the surrogacy lined up and the biological mom, I'm not sure if you call them that, has the baby and then says, "No, I've changed my mind. I want to keep the baby." Is that it? Is that a thing? I mean, can a contract kind of trump that?
So, couple things. So usually there's not a biological connection between the surrogate and the baby. Most cases that we work on in California are gestational surrogacy cases, meaning that they're gestating the pregnancy, but they are not the egg contributor. So an embryo is created, transferred to the surrogate, there's no biological connection. I have clients all the time who are really worried about surrogates changing their minds and wanting to keep the baby. And I will tell you that every surrogate I've ever worked with is like, no, thank you. I have children of my own. I do not want this baby. So I've never had that come up, and I don't think I know of any of my colleagues who have had that come up either. We have unfortunately seen the opposite occasionally, where parents divorce maybe mid-pregnancy or something happens, and pretty rare, but I have had a couple cases where the parents have changed their mind, which has been quite devastating, but never in a case where the surrogate has changed her mind.
So what happens to the baby then?
Well, the parents, under the terms of their contract, they have to take, they just like any other parents, this baby is their responsibility. So, like any other parents, they can take responsibility for the child. They can choose to relinquish the child for adoption. Fortunately, I've only had two cases of all the cases I've worked on where this has come up, and in both cases, the parents retained custody of the child.
Rose, I feel like this field that you're in is similar to family law, where your heart is probably just breaking like all the time. Is that the case?
Yeah, I mean, I remember starting my practice thinking like, I'm helping people have babies. Every day is going to be butterflies and rainbows. It's so happy. And most of my cases turn out really smoothly and beautifully. I'm transactional only in my practice, so I'm not taking on cases where there's litigation or where there's conflict. I'm just drafting and advising on contracts. But it's heart-wrenching because sometimes people come to me, like for same-sex couples, for example, they come to me and this is how they're starting their family, and there hasn't been years of infertility or trauma that they've gone through. But many, many of my clients have gone through years of loss and struggle, both, emotionally and physically and financially. And so by the time they get to the point of needing a fertility lawyer, it's really pretty devastating and it's really hard. I mean, I don't think anyone thinks about talking to a lawyer when they think about having a baby.
No, no. I mean, maybe they should.
Did you know my mom has a monthly newsletter where she shares helpful information? Click below to join.
Well, so Rose, let me actually tell you, I actually had three miscarriages before Caleb was born, and it
Oh.
was it was a really hard process. And so I can't imagine if that kept going on and on. And then I remember after Caleb was born, it was so joyful. And then they let me out of the hospital without like having to sign anything or take any classes. I was like, "Are you sure? Are you sure I get this kid?" So sometimes I
Yeah.
feel like people should actually legally have to have something to be a parent, because a lot of us
I
we
know.
we don't know what we're doing. But that's neither here nor there. But I just thought,
I
like as
remember
you
thinking
mentioned.
the same thing, like to the nurses, like, you're not coming home with me? I need you at home with me.
Exactly.
Yeah, I get that completely.
That's right. That's right. Well, so let's talk a little bit about what should go into an estate plan, do you think, to really make these things really clear? Because sometimes people are afraid, like if they've had their kids using ART, then, they're worried, okay, maybe somebody won't acknowledge that they are actually their children who are intended to inherit. Do you have any opinions on that?
Definitely. I mean, under California law, eggs, sperm, and embryos are all considered property. So they should be disposed of as property in your estate plan. So just like any other property. And I think it's really weird to think of them as property because it's obviously emotionally very different. But when we are talking about like estate planning laws in California, they are viewed as property, meaning they need to pass under the terms of the estate. So when people are going through fertility treatments through their doctor's office, they usually sign a disposition consent form with their doctor's office, which usually tells the clinic what they want to have happen. If they separate, if they divorce, if something happens to them, like if it's a married couple, for example, who are going through this together, so that the clinic knows what to do. But the forms that clinics ask people to sign are pretty bare bones. And so, in my opinion, estate plans really need to have some robust language about what should happen. There are so many different options. So, for example, if somebody has completed their family and they have four remaining embryos, the options are they can destroy them, they can donate them to medical research, or they can donate them to another family to use. And those options should be really clear, and it should be really clear what should happen. If do they both agree on that? If does only one person agree on that? If they're donating to another family, what are the terms of that? Is there a certain does that family look a certain way? Not in terms of like their physical attributes, but like do they live in California? Do they live somewhere else? Are there religious affiliations that are important to them? Things like that I think are super important. And same with research. If you're donating to research, are you okay with kind of just a broad stroke of research? Is there only very specific research that you're comfortable with? And so these are things that really should be outlined in every single estate plan.
Okay, so now let's say that somebody has those four embryos left over and then they don't have that specified and then they pass away. Would those four embryos as property go to the beneficiaries of the trust and then the beneficiaries get to decide what to do with the embryos?
In theory, but it also depends on what the consent form says that they signed with their fertility clinic. So if the consent form on file with the fertility clinic conflicts in any way with their estate planning documents, I think it could result in a battle to determine which document would control in that scenario.
Whoa. All right, so that should make estate planning attorneys pause mightily. before putting anything in, because you don't want to put something in that conflicts with the contract at the fertility clinic, right?
Right. So I always recommend asking your clients, did you go through fertility treatments? Do you have any eggs, sperm, or embryos that are cryopreserved? If so, you'll want to review their consent form, their disposition form that they have on file with their clinic. It's usually like a very simple, like 2-page, like check marks, like, yes, I want to have them cryopreserved, or no, I don't. And that's something that you'd want to review just to make sure that it is consistent with the terms of whatever estate planning documents you're drafting.
Oh my goodness, Rose. I don't think I've ever had a conversation like that with a client. Yikes.
I
But
think a
but now
lot
I
of people
know.
don't know to. I mean, I
Yeah.
think this is one of those intersections of two different areas of law that perhaps you might not even know to ask for if it's not something that you're dealing with every day.
Wow. Oh, I'm flabbergasted. I mean, this reminds me, honestly, I do see a lot of connections with like family law with this practice,
Hmm.
in that, when you do a prenup, a premarital agreement, then the estate plan needs to match the prenup,
Right.
right?
Right.
And so I always ask in my intake questionnaire, do you have a prenup? So maybe I should also ask, have you utilized assisted reproductive technology? And
Hmm.
then that can be my cue to talk with my clients about this.
Absolutely. Definitely.
Whoa, do you see the light bulb going on?
Yes, and this is so new, right? I mean, this is so new because we have this technology is changing so rapidly. And I think the options are also changing fairly rapidly as well.
Yeah. Now, you said that you practice in other states and around the world. Is that right? Is this federal
So
law?
I'm only licensed in California, but I have clients who come from other states to California to utilize either our medical services here or work with a surrogate, egg, or sperm donor in California.
Okay. Because one thing that I've started to worry about as you were talking is what happens if California, we lose our ability to choose, right? If we
Right,
can't choose about disposition of embryos, right?
right.
Like other states must have right now.
Right.
Ah,
I mean, that becomes a really big deal because then if all of a sudden embryos are afforded personhood status, for example, which we've seen a lot of legislation and bills come through other states that are affording embryos personhood status, then no, in my opinion, they lose that property, quote unquote, characterization, right? If they are people, they can't be property. And so then the disposition of these eggs or sperm or embryos is a very different conversation in estate planning. I don't really foresee that happening in California, but certainly something that we want to revisit in detail if it ever did.
yeah. And can I just go on a rampage that the woman who sued because she was driving in the carpool lane and she was pregnant in Texas, and
Yeah.
she wasn't allowed to drive in the carpool lane, and yet the baby, the embryo had personhood status. Like, how do you even
Yep.
thread that needle? Okay, I won't go anymore.
Yeah,
This is
I'm
not a
with you.
political
We are
channel,
aligned
but
completely. We are completely aligned on that one.
yeah, yeah,
Yeah.
very interesting. Okay, so
Yeah.
people usually come to you when they're trying to conceive, when they're trying to have a baby using extra help. Are
Yes.
there any other times that you help your clients? Are there any other situations?
Yeah, so one thing I do a lot of is a lot of my clients are same-sex families. So two men or two women, and in those cases, often one of them has a biological connection to the child, while maybe the other one does not. And in those cases, whether or not they're married, legally married, I always advise them to do a second parent adoption. And that second parent adoption, otherwise kind of referred to as a confirmatory adoption, confirms the legal rights of the parent who does not have that biological connection to the child. And as part of that second parent adoption, even if both of their names are on the birth certificate, it's part of that second parent adoption that also usually gets added just to their estate planning documents, just to make it really clear that both parents, intend for the children to have full testamentary rights and things like that. But that's something that's obviously really important and that we are dealing with a lot, especially as we see potential changes to same-sex federal marriage protections.
Right. Oh boy. Yeah, so this is a moving and changing field. That actually was a situation in my family where on my husband's side of the family there was a same-sex, the sister of a family member who they have a wonderful child who has a biological connection to the other partner, but then they broke up. But I think they
Mm,
still both have parental rights. And so in that situation, I'm sure she must have done the second parent adoption, and how important that is to
right.
make sure that you maintain your parental rights and connection and visitation and everything like that.
Exactly. And in those situations, if you're working with same-sex clients, my advice typically and is that the parents, so let's say it's two women, they should, in my opinion, name each other as guardians, primary guardians, before they even name an outside family member or friend as a guardian of their child. Because if in some scenario we see a situation where their rights are stripped, their parental rights are stripped, then at least they have this legal guardianship document that allows them to have those powers. Basically, what we'd want to do is legally recreate whatever their parental rights would be.
Yes. And I have to tell you, Rose, in my guardianship nominations, I typically do that anyways, even for opposite sex couples. You know,
Good.
name
Perfect.
the other parent first, right? Because you
Yeah.
can never be too careful, right? Yeah.
Exactly. Exactly.
Wow. Boy, I'm sure there must be so many other questions that people are coming up with, but our time is kind of coming to a close. But Rose, I want to thank you so much for opening our eyes, or at least my eyes. I'm sure other people as well. And we'll put down on the bottom of the screen how people can reach you, and they should. They should definitely reach out to you, and because you have such an amazing subspecialty, and we will work on making sure that we are up to speed on really assisting the really special group of individuals that you serve.
Oh, absolutely. And anything I can do to help, don't hesitate to reach out. But I really appreciate you having me. This is fun.
Oh, it's been a pleasure. All right, thank you.
Thanks, Ellen. Talk soon.
If this video is helpful for you, share it to someone else who might benefit from it.